This educational program is intended for the personal, non-commercial use of its listener and may not be reproduced for any commercial purpose without the written permission of Rex Crandell and CALDA. The policies, positions, views and opinions expressed and or provided herein are not those of the State Bar of California, CALDA or any entity associated therewith, and are strictly those of the authors or speakers. No representations or guarantees of any kind are made with respect to the accuracy of the written, visual, oral or audio portions of this presentation, and nothing herein should be relied upon to answer any legal questions. The written, oral or visual information expressed or provided herein should not be relied upon in dealing with any specific legal matter. No attorney-client or CPA-client relationship is created by any part of this educational program and related activities. Attorneys, CPAs or LDAs using the information expressed and provided herein in dealing with a specific client or clients, and their own legal matters should also research original sources of authority.
Okay.
All right, awesome. So welcome, you guys. Welcome once again for Trust Part 2, Revocable Trust in Estate Planning. Of course, we have the wonderful Rex Crandell, who will be presenting again. He has many years of experience in bookkeeping, accounting, financial statement preparation, audit reviews, and consulting. He also prepares estate planning and he does probate. So welcome, Rex.
Okay, thank you. And welcome everybody in the audience today. I have got what I think is the most important things. This is not just a rehash of the first class on trust. We're going to dig deeper and get into more of the fine points and practice issues. So the way that we'll run the class is we'll hold the questions unless Michelle Dugenet thinks that I should be interrupted for the questions, and we'll hold them to the last. And then we'll have a question and answer session as long as anybody still has questions. I'm okay with that. And we'll go through step by step. The learning objectives for today are planning for married couples and blended families, in addition to married couples that are not blended families, proper beneficiaries for certain assets, amending and restating a trust, funding a trust for business assets, useful trust clauses to consider, and estate planning ideas and alternatives. So I'm going to explain our class materials today because it's we're doing a little different than last time. The segment, that part of my book, is still here for the trust, and I wanted to make sure that everybody understood what the information is here. I want to thank Colleen Marie for making this Funding Your Trust document available for everyone. And if you do make a trust and you don't fund it, it's worth less than the paper it's printed on. It's completely worthless, and we have them come in from time to time. And this detailed report tells you and your family members, or if you're working with a third party, what items need to be titled in the name of your trust, and gives you suggestions on how to do that process. Another way that some people would probably want to use this Funding Your Trust is oftentimes a person might do an estate plan, and then at the end, they'll allow the client perhaps 60 days to ask questions, no charge. And, you know, for the first 60 days. And then if they haven't funded the trust beyond that, then that would be an additional service that could be provided because it'll make the trust work like it's supposed to. And sometimes people need help in funding their trust. So it's got quite a lot of detail in stocks, personal effects. Anyway, this is the funding your trust handout. Item 1D is in Delta. And next I have two estate planning brochures. I want to thank Tamara Brown for this one. It was created for callegaldocs.com. And it's a good overview. It's trying not to dazzle anyone with big words or, trying to make it user friendly so that the average person who does not have a legal background can understand it. And it was approved by attorneys. The other estate planning brochure that I've included in your materials is from CalDA. And I want to thank Jim Wilroy for these. It covers a lot of detail. It has quite a bit of information on the transfer on death deed, character of property, and holding title, explanations of probate. He has a good chart here on the probate fees and the various levels of assets. And it's quite detailed. And it's very good, and it is available on CalDA's website. So those are available for you. And the next one, I'm kind of excited about it. It's in trusts, we have a problem sometimes getting the right trustee, making sure the trustee is honest, gets along with the other people. And sometimes it just doesn't work out where there's a good fit for who's going to be trustee. This is an article that came from Estates and Trust Quarterly by the California Bar Association. And it has in the beginning, it has explanation of various aspects of hiring a professional fiduciary, qualities, and also it explains about getting a professional fiduciary license. Some people may want to do that, become a professional fiduciary with the state of California. There's education and a test, and then you can act as a professional trustee. But these paragraphs I find very interesting. So these paragraphs help you in estate planning. Appointing a professional front trustee by a family member. So family member wants to get out, okay. And optional appointment of a family member appointing a trustee. And here's another set of clauses. So the clauses are set up. You got trust, whether there's going to be a trustee bond. Here's will provisions and also durable power of attorney provisions. So it enables you to go through a comprehensive estate plan and include the descriptions of things that will bring in a professional fiduciary. And here's another one, nomination by family members. So it comes from different angles. And this Appendix D is very useful because this is a model agreement for hiring a professional trustee, a licensed professional fiduciary. So it has all kinds of terms and requirements and things to remember. And it's very thorough. So it definitely can be used as part of the process of appointing someone as a trustee when a family member or friend is not available. Okay, so funding a trust, we just covered that a little bit. All assets must be funded in the trust for the trust to have it any management ability. It's like a corporation. Corporation president can manage all the assets in the name of the corporation, but if it's not in the name of the corporation, the president can't do anything with it. Change title for any property that has a registered title. For example, real property is a major one. Vehicles, I don't usually put into the trust because DMV is somewhat lax in allowing the transfer of vehicles on death. And the other problem I've had with DMV trying to fund a trust is DMV wants you to go over to Board of Equalization and see whether they can charge a sales tax. And if it is in fact a gift, then there's no sales tax. And then they send you back to DMV. So cars we leave out. Generally pensions we do also, IRAs. And there you want to verify the named beneficiaries on those accounts. You don't usually want to name the trust as the named beneficiary because of the beneficiaries have income tax elections that they can make, but a trust can't make those elections. We also include an assignment of all personal property. And it doesn't define, you can put detail in there, but it's basically everything that the person owns, the settler. And this is a concept. We have always, it's been traditional that estate planners will give their clients a letter. Let's say they have a Charles Schwab account, and the estate planner will give the client a letter they mail to Charles Schwab and say, please transfer my account into the name of my trust. Me as trustee is for the trust. But it's come to my awareness that this doesn't work. This plan of just sending a letter might have worked at one time, but with this world of websites and online forums and things, it does not work. So what I would do is if the person had, no internet access, then I would give them the letter and say, bring this to your financial institution and ask them to change the name on the account to your trust. A better way to do it now, in my opinion, is to go on the vendor's website and look for their transfer of ownership form, and you can copy that web page and print it for a third party saying that if you want to change your account to a trust, you need to do this. I recently had that on my own trust where I changed the name with a Charles Schwab account, and I couldn't believe the detail they wanted. It was about a 12-page document. And then somebody from back east calls me and asks all kinds of questions that I thought were pretty dumb, but they were going on the bank secrecy and money laundering requirements that the vendor had. But just giving a letter to the client and say, mail it, I wouldn't rely on that anymore. Okay, for married couples who have been married for a very long time and most all their assets are community property, oftentimes we'll prepare what I call an I love you trust. So this trust, we have a settlor, debts and assets, and the trustees. And on the first death of a spouse, nothing changes. It still stays revocable and changeable. And the surviving spouse continues to be the sole trustee. The surviving spouse has the right to spend all trust assets. There's no restriction, and there is no irrevocable or non-changeable be or bypass trust on the first death. So it leaves the surviving spouse in complete discretion about the assets and it works well for a couple that has all community property and all their kids are of their current relationship. I see a lot of court cases that come out from blended families where the spouses have children from previous marriages. And the term we use is blended family. And what happens here is it gets confusing about distributions. One spouse, surviving spouse, might want to favor their children over the deceased spouse. And so we work with a client and make sure that they understand and want some of these provisions to protect the deceased spouse's children's bequest. So the first thing we do, we want to identify the character of the assets. What assets do they have as separate property before marriage or acquired during marriage from gift or inheritance, and then all the property they acquired during their marriage. And that should be documented. And I suggest that spouses prepare a document describing their separate and community property. I've seen many cases where a surviving spouse will remarry, and then the surviving spouse and the new spouse end up depleting the assets for the deceased spouse's children. So this particular method, we call it an AB trust. We used to do it a lot when the inheritance tax above 600,000 had inheritance tax at 37%. It's not used as much for estate tax because the state inheritance tax rate is so high. The name is AB, or we call it a bypass trust. And then there's a survivor's trust, and there's also a credit shelter trust. So we start out as one trust document. And then on the first spouse's death, the trust splits in two, figuratively. And then you have to transfer title to the bypass trust. And the way we do that on real property is we will change the name of the trust a little bit and call it the bypass trust. Then everyone knows that this trust is irrevocable or non-changeable. The A trust, which is everything that we did not allocate over to the bypass trust, we refer to that as the survivor's trust. It's fully revocable and changeable, and it is subject to estate tax, if any, on the second spouse's death. And when the couple's one couple dies or one spouse dies, everything I look at the assets kind of like a ball. And on the first death, the ball breaks in half, and that half has half of the community property of the deceased spouse plus all of their separate property. So it's something to track, and it is called the character of the property. The B trust bypass is irrevocable, non-changeable. There is a state inheritance tax deferral on the death of the first spouse. Well, it usually ends up being deferred based on the lifetime exclusion. And because the bypass trust is irrevocable and non-changeable, if it has over $600 of income during a year, it has to file a fiduciary income tax return, IRS form 1041 or California 541. And then they also have to obtain a taxpayer identification from the IRS so they can make this separate tax return. And we have many clients who have an individual tax return that we prepare, and then they've got a bypass trust that has separate assets, and we report that. The memory aid for the AB trust is A for above ground and B for below ground. So what we're talking about on a traditional AB trust is that the document requires the splitting of assets from one trust into two separate trusts. Now, if you make it optional, it's not going to protect the deceased spouse's children, but sometimes people will make it and they call it a discretionary trust. And the surviving spouse can decide to split it or not, whatever they want, if they decide to. And this has some popularity, partly because of the estate and inheritance tax exclusion. Right now, you have to pay inheritance tax on assets above 12 million for a single person, 24 million for a married couple. But starting in 2026, the law has changed or will change so that inheritance tax comes in at 5.5 million. So by putting this discretionary trust in, if a client has that asset level, you give them an option to avoid inheritance tax. Okay, this is a schematic on how an AB trust works. We have husband's pour-over will. We have the wife's pour-over will. We transfer assets into the trust, and then one of the spouses dies. And normally for entertainment, we have the husband, we kill the husband first for example purposes. And that one trust now gets split into a survivor's trust and a decedent's trust or bypass trust. So we have two separate trusts, the survivor trust, revocable, changeable. The deceased spouse bypass trust is irrevocable, non-changeable. And the traditional bypass trust allowed for the surviving spouse to invade the principal for health, education, maintenance, and support. We call it HIMSS. And in trying to protect the deceased spouse children, you might consider not giving the surviving spouse a right to invade the principal. Some trusts will be written where the survivor's trust must be fully depleted before invading any principal in the bypass trust. Another common clause in a bypass trust is the surviving spouse is given the right to take out $5,000 a year or 5% of the asset value. And that's another distribution that you might consider not including. Then on the death of the second spouse, both of the trusts are distributed after administration to the beneficiaries, and you should keep assets in trust for children under 18 because a child under 18 cannot have more than 5,000 of assets in the state of California. Okay. We went over those items. Okay, transferring ownership of business assets to a trust. There's several different types of businesses or ownership types, entities, and I'll go through each of them with suggestions on how to fund that particular business entity. So your client comes in, or yourself or family member owns a business. First, you need to find what is it, what kind of entity. So most common is a sole proprietorship. And the way we transfer assets for a sole proprietorship is we use a business assignment of personal property form to express that all the assets in that business are now owned by the trust. And we include references to contracts that the proprietor is involved in. And sometimes there's other documents that need separate assignment, long-term contracts, maybe prior accounts receivable. You just have to look at the balance sheet of the sole proprietorship. Okay, so your client owns a limited liability company. Let's say there's 4 owners and they formed, instead of a partnership, they wanted a limited liability company, and you want to transfer it into the name of the trust. Okay, fine. You can do a business assignment of personal property and it may work. But what happens in real life is that all LLCs have what's called an operating agreement. And so if you have 2 owners, 3 owners, 4 owners, they may have restrictions on the transfers of the membership shares. So they might have a first right of refusal. They have a certain fixed price they can buy the deceased person's shares for. And usually what I see is the surviving owners do not want to go into business with the surviving spouse that maybe doesn't have any business experience in that particular field. You might also consider issuing new stock certificates or LLC membership certificates in the name of the trust. We frequently do that. We order the stock certificates in the entity's name from the legal publisher, and then we issue the certificates in the name of the trust. So there's no question. The LLC, you hold up a share of stock and it says, yes, it's owned by the trust. There's other kinds of businesses that have different procedures. If there's an ownership in a limited partnership that's publicly traded, or ownership of stocks and bonds that are traded publicly, yes, you can use a business assignment of personal property to transfer those assets to the trust. What happens sometimes, and we've had to work through it, the person has ownership in a limited partnership and they don't have any share certificates. So they can't transfer it to the trust. They say, well, I never got any certificates. Well, if it's publicly traded, for each corporate or public entity, there has to be a registrar, and that person keeps track of the owners for that company. And the one that we run across the most is ComputerShare. And we've had to reissue limited partnership shares, other kinds of stocks. And then when we get them in back into the estate, the trust, then people don't really want to hold the certificate. So we suggest they give it to their stockbroker and put it on their portfolio. And the forms that ComputerShare uses, they will not accept a notary. You have to go to a bank and get what's called a medallion signature that says your identity. Okay, other business types to transfer: S corporations and C corporations. An S corporation is a flow-through entity, sometimes called the Lipton tea bag of corporations. The net income is not taxed for federal, and it flows through right to the tax returns of the owners. So if there's 4 owners, equal ownership, you have 100,000 of net income, 25,000 comes out to each owner on a Form K-1. And then there's the C corporation. All corporations start out when they're born being a C corporation. And then if they do the proper election with IRS, they can morph into an S corp. For C corporations and S corps, you can use a business assignment of personal property. Fine. And if you want to know, how do I tell the difference between a C corp and an S corp? We have clients that don't know and they own them. You look at the tax return for an S corp, it files a Form 1120S. and a C Corp files a Form 1120 without any initials. And here again, we have the suggestion about issuing new stock certificates in the name of the trust. But the difference in the corporations is on the limited liability, we talked about an operating agreement. In corporate vocabulary, they have what are called bylaws. And you have to look and read the bylaws to make sure that there's no transfer of ownership restrictions. Because if you transfer it contrary to the restrictions in the bylaws, your company is not going to be owned by your trust. This is an example of we buy a pad of these certificates made out in the name of the entity for their company specifically. Okay. It's a warning, a reverse mortgage can destroy your home going to your children. A reverse mortgage must be paid in full when the homeowner no longer uses the property as their principal residence. They die, or they permanently go to another home, skilled nursing facility. And then what happens, that the loan becomes due. So the children cannot even inherit the property, and the property must be sold within 6 months, or the lender in FHA will foreclose on the house. And I think it's a bad thing that the adult children cannot inherit the house. We have a very valuable tool for inheriting children, that if they inherit a house with a very low property tax level, you can claim a parent-child exclusion from reassessment so that the adult child gets the property at the low property tax value, but they have to live in the house, and they also have to file for a homeowner's exemption. But I think it's really bad that here's the house, you'd like to give it to the children, and the reverse mortgage just stops it. Okay, how do you amend a trust? What we do is start out looking at the original trust, find the clause that says the trust is revocable or amendable. Then we copy and paste that entire clause verbatim into the amendment. We get clients in that have trusts, they want them amended, and I've worked on trusts that had 5, 6, 7 amendments. It just drives you crazy trying to keep up with this was then and this is that. If a client comes in after 2 amendments, we will not amend it a 3rd time. We rewrite the whole trust and restate it, or cancel the first trust and restate it entirely. We keep the exact name of the trust rather than changing it, even though all the terms may have changed. And the reason we do that, let's say you have 5 rental properties all in the name of your trust. If you amend and restate your trust, you do not have to go in and change the name on those deeds if you left the trust name the same. A problem we run into from time to time is people will amend a trust, and the trust name frequently has date of trust document or under agreement for the date the trust was originally formed. And then they'll amend it and they start using that amended date, and it's wrong. You should use the original date the original trust was formed. Every time we amend a trust, we add another document called a general assignment of personal property. And you do that for every amendment, because between the time of the last trust amendment and now, the settlers may have acquired a lot of personal property, so it takes care of that. The term codicil is not a trust term, it's amending a will. We never amend a will, we just start over. Most of our wills are pour-over wills, so it's fairly easy. A pet trust, you can do it informally, leave some money to a trustee and ask them to take care of your trust, or like Animal Rescue Foundation, we've had that taken care of before. There's a specific probate code section. And if you use that, you can have an enforceable pet trust. The other way, where it's informal, it's called precatory. The term is a legal term on wording. Precatory means it'd be a good idea, but it's not binding or required by the trustee, nor will a court enforce it. And if you have a pet trust, more than 40,000 of assets in it, then the trustee needs to turn in the accounting, fiduciary accounting every year. And one word to the wise, when you put in a pet trust, you say until Scruffy dies, we're going to have a pet trust. Make sure you put the words natural causes, because there's been cases where there's been a pet trust and then the trustee beneficiary wants to speed things along, so they take the pet in to be euthanized and destroy the trust. This next concept is a procedure, a function of a potential idea that came from England, and this is not a trustee. You add another person as a trust protector, and that trust protector is not considered a fiduciary, and they're not involved in the day-to-day activities. You can give the trust protector a lot of responsibilities for oversight. You can use a trust protector to make sure the settler's wishes are carried out. Sometimes I'll name myself as trust protector or any other California attorney, because we have a trust that we know is going to need a bunch of documents prepared in the future, and the trust protector can be given the right to do that. What you want to do is grant whatever you want to put in it. You could any disputes between beneficiaries is decided by the trust protector. You can have the trust protector allocate assets between children, college or disabled children. You can have a trust protector oversee if a beneficiary is chemically dependent, verify that they have a clean blood test before they get any distribution. There's no limit. But you need to identify who this person is, that they're competent and willing to serve in this capacity. These are some of the things that people have used trust protectors for. Changes in beneficiaries, amendments for the law changes, disputes between beneficiaries. We have a new birth in the family, and override investment decisions. So it's a useful useful procedure. We don't use it every time. When we see a need for it, we do. Now, give you a big warning on non-citizen spouses. If you have a couple and one of the members of the couple or partners are non-US citizen, it should always raise a flag in your mind, because there's a huge problem lurking here. So when I say non-US citizen, a resident alien is a non-US citizen. So it applies to non-resident aliens too. And what we're talking about here is estate and inheritance tax. I previously mentioned that when you have assets above 12 million for a single person or above 24 million for a married couple, you have inheritance tax on the value of those assets at above those levels at 37%. Well, for a non-citizen, it is completely different. Every distribution above $164,000 is taxed at 37%. And I want to clarify some terms here because it's often confused. Just because you avoid probate does not mean you avoid the estate and inheritance tax. They're different laws. Probate operates under state law. Estate and inheritance tax operates under federal law, but you should also be aware, depending on the state of residence, many states like Pennsylvania have state inheritance tax that should be considered. Okay, what's the solution to assets above 164,000 going to the non-citizen spouse? There's a trust called a qualified domestic trust, QDOT for short. We do them fairly rarely, and it's to avoid the inheritance tax on that amount and make it more economical for the surviving spouse that is a non-citizen. There are requirements for the QDOT, and that is one trustee must be a U.S. citizen so that U.S. courts have jurisdiction over that person. The other trustee can be the non-citizen. And the way that this works is all the money goes into this QDOT. You have the citizen trustee, and there's no inheritance tax due on that first transfer. However, when the non-citizen spouse starts drawing money out of the QDOT, once they hit 164,000, every dollar distributed after that point is taxed under estate and inheritance tax at 37%. I think Congress's idea with this was that they did not want non-citizens inheriting a lot of assets and then just taking the money out of the country. So this puts a block on that. Okay, when does a trust cease to exist? There are several possible answers. When the trust purpose has been achieved and there's no assets or liabilities in the trust. After the trustee's done a final accounting for the beneficiaries. To try to end a trust, oftentimes a trustee will do a final accounting and want to end the trust and ask the beneficiaries to sign a waiver that they're not going to sue the trustee. And a trustee does have the right to ask beneficiaries if they'll sign a waiver. And so there's no claims. However, it cannot be mandatory. In other words, the trustee cannot say, sign this waiver, you're not going to sue me or you're not getting a distribution. That is clearly prohibited. But what trustees do in this predicament, say that there's been rumbling of litigation from the beneficiaries, the trustee can take the final accounting and submit it to the court and have a judicial acceptance and approval of the accounting and a termination of the trust. And because there's a notice for all beneficiaries that they can object to anything on the accounting, and if they do, fine, it'll be handled by the court, and if not, then they lose their right to sue the trustee for anything disclosed in the accounting that's been approved by the judge. Trust also ends when the purpose becomes illegal or impossible. Trust is revoked. Oftentimes you'll have a trust that has no assets, it's dormant, and then perhaps a new asset is found. Sometimes after a trust has been, everybody thought the trust was extinct or terminated, someone will come up with a liability that they want the trust or the estate of the decedent to pay. And there's a very clear statute of limitation under California law that a creditor only has 1 year from the date of death to file a creditor's claim against a estate or a trust. And if they do not file a creditor's claim within that year, they have no right to claim anything. So it's something to keep in mind. Okay, so this is another advanced concept, and that is giving the trustee the right to move the situs of the trust to another state. So we have a California trust, and let's say the person's a high tech and they've got a huge amount of stock options and stock in Apple and Google, and they don't want to pay California income tax. Well, this concept may not work, but the concept is you take the trust and have the trustee change the jurisdiction. They move to Idaho. Now you have an Idaho trust under Idaho law. And then sometime 2 years, 3 years later, that portfolio is sold. And some will argue that California cannot tax it. But I do point out the Hyatt decision that kind of held otherwise. But this concept should not be applied if there is California real estate. It doesn't matter whether you have a trust in state, out of state. California real estate being sold is going to be taxed by California. So another question comes up: which state can you bring litigation against a trust? Well, it's simple in California. You have a California trustee, California trust, California settlor and decedent. Guess what? You're in California courts. But for example, we have a client who the trust is being administered in South Carolina. All activities are in South Carolina, and there is some property in California. Well, if a disgruntled beneficiary wants to sue that trust, California Probate Code Section 17002 says you must sue in the place of principal administration of the trust, where the primary person responsible for the administration of the trust lives. And this is a good technique if you have known litigious beneficiaries to never let the trust be administered in the state of California, because it's more difficult to maintain litigation in South Carolina than having assets in California, where there's a lot of resources that can be used in court. Sometimes you'll run across an estate plan where the settlor says, I've got 5 kids and I want to give one of them nothing. Okay, you can do that. I would list them in the trust or an estate, and I would do something different than just ignore them. If you ignore them, they can charge against the estate as an heir or omitted spouse or omitted beneficiary. So one concept that we came up with is you take the objectionate beneficiary and you give them, let's say, a nominal distribution of 50, 75,000. And then in the trust, you write that if this beneficiary takes any litigation against the trust, the trustee, for any document, anytime, that this distribution will be redirected to a charity. And the reason we do that is if litigation is started, you let a charity know that there's some money on the table, and they will send an army of lawyers to secure their right to that money. You think charities are nice? You should see them in court. They're mean, and they will fight tooth and nail for their, in this case, it would be a charitable donation. What's a no contest clause? Well, you probably already know. It says if you sue the trust under certain circumstances, you lose your right to inherit. So some of those that are considered by the California, a few years ago, the no contest clause in California was watered down, and it's limited now. One thing that you can remove a beneficiary from, if the beneficiary challenges the transfer of property that and claims the property didn't belong to the transferor. If a beneficiary files a creditor's claim, or if the beneficiary brings lawsuit without probable cause, also known as harassing the trustee. Some examples that we have come across where beneficiaries are removed from a trust. The way they're removed, it says, if you do these acts, you're going to be treated as you predeceased the settlor and you had no children. So it pretty much leaves them nothing. There was one case we saw where a disgruntled beneficiary lived rent-free in a house, and the trustee had to file an eviction. And the court held that the trustee was trying to break the trust by not following it and having to be evicted. Another example we've seen is where a trustee misappropriated a large amount of assets, and the court held that the trustee completely disregarded the trust and they're not going to be a beneficiary. Now, the bad news. In California, we see trust litigation frequently, and most of the time it follows this template. So a disgruntled beneficiary asks the fiduciary, the trustee, for an accounting for the entire time the trustee's been on the job. And the trustee is required to do that under code section 1060, probate code. And if it's not done within 60 days, the beneficiary can sue the trustee to try to get them removed. So if they do the accounting, then the trustee can sue on anything real or imagined that's in the accounting. But let's say the accounting is not done. Then this is the template for litigation. They file to force an accounting. They make the trustee do that. They want to remove the trustee and put another trustee in and have the existing trustee answer many real or imaginary complaints. And they want to remove the trustee and put a friendly trustee in for the beneficiary. The litigation continues, perhaps for years, and the now former trustee is still involved in the litigation. But get this, they have to pay all their defense litigation out of their own pocket because they do not have access to trust assets anymore. And to add insult to injury, the beneficiaries always ask that the former trustee pay all attorney's fees, legal costs for causing this real or imaginary problem. arbitration clause. If you like arbitration clauses, you might want to read the MacArthur decision, because the California Appellate Court just recently decided that there was an arbitration clause and a beneficiary challenged it in the trust. And the court held that the arbitration clause, even though the settler wanted it, it was clearly described, it was their wishes. The court held that it was not enforceable because the beneficiary was not a signatory on the arbitration clause. Now, this is the first time I have ever heard that a beneficiary has to get involved in an estate plan, but sometimes you need to do that. Decanting. Okay, the word decant comes from wine. So you have a long-term bottle of wine with sediment in the bottom. And then you want to get the sediment out, but you don't want to stir it up. So you slowly pour it into your new wine bottle and you leave the sediment behind. And that analogy is used to describe decanting a trust. California allows it under probate code section 19501. And you can take, let's call it an old trust that has some terms in it that are undesirable, and you can create a new trust and transfer the assets over to the new trust by decanting. And I'm not going to go through all the details on the procedures, but just keep it in mind that it is possible to do decanting of a trust in California, even if it's irrevocable, non-changeable. Okay. Let's say you have a situation where the settler died and now there's a large amount of cash, and the trustee is worried, rightfully so, that this, let's say $2 million of cash is not protected by FDIC insurance because it's in one account. Well, there's a new concept put out by a company named IntraFi Network. IntraFi Network, and one of their agents or one of their banks is Manufacturers Banks. There's about 85 of them in California. The way that this system works is you open up one bank account, let's say with 2 million in it, and then you contact the IntraFi Network and they transfer funds to all these other banks at 240,000 per account. You only have one prime account, but you have FDIC insurance for all the money. It can go up into the millions. And the member banks that are holding the separate 240,000 accounts do not have the personal information of the trust or the trustee. Introduction to trust administration. So settler dies. Now we have an operating trust, let's say a single individual. What does a successor trust do? They read the trust document. They look around and see if it's the final version. Are there any amendments? Look over and try to find assets. Look on the Schedule A of the trust. Read the pour over will. Look for the deeds transferring the property. Sometimes people will seek out the drafting attorney to ask questions. Is there only one trust? And a big problem nowadays is our logins and passwords. So you get a situation where a person has a large amount of bill pay accounts with all their creditors, and it's through the bank, and the trustee cannot get in to change the bill pay or change the vendors. And so we always suggest giving the successor trustee the login and password for all online cyber assets. Cyber currency is an absolute nightmare to try to track down. There's so many sub cubby holes that it's just amazing. But trustee needs to gain access to those assets. And I'd be willing to bet a lot of cyber currency is going to be lost and the beneficiaries will never get it. The purpose of trust administration. Okay. Now, you normally think, and we've been talking about the settlor dying, but trust administration is equally enforced when the settlor becomes incapacitated. When a person who has a trust, a pour-over will, durable power of attorney, financial management, and advanced healthcare directive, when they're determined to be incapacitated, they're kicked off their job as trustee and the successor comes in. Their durable power of attorney for financial management, the agent now is in charge of all the assets outside the trust. The will is not affected because the will only speaks at death, so incapacity means nothing on a will. Then there's the advanced healthcare directive that the individual is incapacitated no longer makes their own health decisions. So that's one of the reasons why we insist so much on a durable power of attorney for financial management, so that they can take charge of the assets. One thing that in terms of trust administration and its ancillary agent under durable power of attorney is that sometimes the banks won't recognize the durable power of attorney. So when you do the trust and the durable power of attorney financial management, make it clear and make it somewhat easy for a determination of incapacity. Now, assuming you have, or the person is incapacitated, they have a durable power of attorney for financial management, and they have an agent ready, willing, and able to work. Okay, that agent can manage the assets that are not in the trust. The trustee can manage the assets in the trust, but there's another side of this coin, and it's called a conservatorship. And a conservatorship may still be needed for the personal care and living accommodations and other aspects dealing with the care of the incapacitated person. Okay, the successor trustee looks over, tries to find all the assets, looks in the mail, tries to find tax returns for assets, search public records. This is a fun one. Check the state controller's office for unclaimed property. We have seen tens of thousands of dollars as cheat to the state that we go and get back from the state for the heirs. It's unbelievable. Always check that when anybody passes away. And a big problem with houses and real property is the settlor puts it in the trust in the beginning. Okay, everything's fine. Now they want to refinance. The bank makes them take it out of the trust, put it in their personal name, and then the settlor forgets to put it back in the trust. Then they die, and now the house is not in the trust. And at first blush, it looks like you have to do a probate, which most people don't want to do. And there's this court case, there's Hegstead and Ukelstad, there's two cases, where you file a petition with the court, tell the court that the trust indicated that this property should be in the trust. It was listed in the Schedule A of the trust, and we're asking the court to put it back in the trust. They kind of end up making the trust kind of equivalent to a transfer deed because it was notarized. It described the property with particularity. And the Hegstead works to avoid probate most of the time. There are judges who will not grant a homestead and they force you into probate. Okay, so determining assets, who's responsible, we talked about that. Successor trustees, initial tasks, I think we've discussed that. Trustee risk management, it's a thankless job for a trustee, unfortunately, because of the beneficiaries and what they have to do. So the typical, not typical, but frequent beneficiary comes up when we kid about it in the office. They have a song. Where's my money? Where's my money? Where's my money? Where? And I don't care what you have to do. Where's my money? And they become quite impatient. And we've worked with many successor trustees, and by the time it's all done, they frequently say this: if I would have known what I had to do and all the hassle to be the trustee, I would have never volunteered for this job, never again. So word to the wise on becoming a trustee. So and the trustee's a target for liability. So you want to look at the document to see if there's a limitation of liability for a trustee. Frequently, it will say, as long as the trustee did not use malice or intentional disregard of the rules and it was kind of an accident what they did, they won't be held liable. If you're a professional, a CPA, a lawyer, an LDA, and you step into the role of trustee, you might want to look to see if your errors and omissions insurance covers you for your services as a trustee. Oftentimes it does not. For trustees, we always suggest that the trustees hire an accounting firm to do the fiduciary accounting so they can give information to the beneficiaries. There's an unspoken rule with trustees and beneficiaries. If the beneficiaries don't hear anything, they start believing that there's some diabolical thing happening out there to their money. It's diabolical because I haven't heard anything. So we advise trustees to just pump out the paper to the beneficiaries, give them bank statements, give them reports. It's kind of like you buy securities on the stock market and then you start getting these annual reports. Well, nobody reads those things. It's just tons of paper. And if the beneficiary is given a lot of information, then they're much less likely to want to litigate. In a trust document, you can put a clause that says to the beneficiary, if you get a fiduciary accounting and you want to file suit, normally you would have 3 years to file and complain about the conduct of the trustee for real and imagined problems. But with this clause, as long as you limit it to a minimum of 180 days, the trustee issues an accounting report to the beneficiaries. They have the full 180 days to whine, moan, and complain and file litigation. If they don't, their right to file the objections is not permitted. So you need, for incapacity, you need to determine how incapacity is determined. It does not have to be a doctor. It can be another person. It could be a psychologist. You decide, but you are ending up wanting to get something in writing. And quite frankly, a lot of doctors are reticent about signing the incapacity declaration. And sometimes, frequently, banks are hesitant to handle the incapacity designation. If there is an incapacity opinion, you might want to ask the settlor who's supposedly incapacitated if they agree with it, because they can go to court and challenge their incapacity. When a settlor becomes incapacitated and the successor trustee comes into power, you have to give notice to all the beneficiaries. Anytime a trust becomes irrevocable. Okay, so we want to make sure the successor trustee has the healthcare decisions. Find out how the settlor can regain their capacity. A common thing that happens is a person gets a urinary tract infection. And what that does is it many times has caused an incapacity declaration by doctors. But then as soon as they get done with that urinary tract infection, they're clear as a bell. So you need to be careful of those things. When somebody's incapacitated, I suggest you consider hiring a geriatric care manager to help with the situation. Find out if the incapacitated person's supporting another person. If so, you might need to clarify it with a court order. Allowing somebody to stay in a house rent-free is a bucket of worms, because when there's multiple beneficiaries, there's always an objection that it's unfair treatment. So if you end up drafting a trust that has the ability for someone to live in a house rent-free, be very careful and handle all kinds of details, how long it'll last, what the terms, do they pay the property tax, who pays this, how is it paid, is it in the trust, do they have to pay it? Anyway, avoid the problems there. There's a duty for a trustee to keep beneficiaries reasonably informed. And like I mentioned before, the beneficiaries can force an accounting. And there's also a provision that sounds like the accounting, but it's a little different, in that if a beneficiary demands an appropriate request, documents like bank statements, like a copy of the lease for the commercial building, or other documents, the trustee is required by law, this code section, to give the beneficiary that. And if not, action can be filed in court to force the trustee to provide that information. If there's no limitation period on objecting to the trustee's duties, the statute of limitations is 3 years. Oftentimes the trustee will ask the beneficiaries to release them of liability. If not, then the trustee goes to court and has the judge approve it. When a trust becomes irrevocable and trust administration starts, there's a requirement in the probate code that you give notice to beneficiaries and heirs that may not be listed as trust beneficiaries, information about where the trust is going to be administered, who's in charge of it, what their phone number and address is. It's just required. It has to be done within 60 days of the date of death. And it's not, you have to give notice not just to beneficiaries indicated in the trust, but anybody else that would be considered an heir under intestate succession. And when we send out this 16006 1.7 notice, we normally include the trust document because the recipient has a right to ask for it. And another problem you want to avoid is you do the proper notices. You've done everything that you're supposed to do. And then the beneficiary says, I never got the note. I didn't know anything about that. So what we suggest is either send it certified mail, return receipt requested. Either that or have a neutral third party do what the courts call proof of service, that it was in fact mailed, and sometimes we'll do that and also email it so that in the future, like the South Carolina case, that everyone knows that the trust is being administered in South Carolina. When can you make distributions? Well, you need to follow trust administration and meet the laws for tax, the probate code, see that rightful creditors are paid. And then you can consider making a distribution to the beneficiaries. Oftentimes there's a process called a notice of proposed action. Or a notice of proposed action is issued by the trustee. And it says, hey, beneficiaries, in 30 days, I am going to be doing this particular thing, and here's the accounting, and you're going to get, $500 million, and these are the expenses, and this person's getting the house. And by giving a notice of proposed action, it allows the beneficiaries notice an opportunity to object. And it helps relieve liability for the trustee. Another item that needs to be done in post-mortem administration is the trustee needs to make sure the final 1040 individual income tax return has been filed. And if there is income over $600 in the trust after death, then you have to do a fiduciary income tax return. And this one that's very important, if property is distributed, see if you can apply the parent-child exclusion from reassessment of property tax. Okay, what does a trustee do? We've looked at these. Sometimes there's an objection about investment of assets, portfolios. The trustee must be very conservative and prudent. A new company, a high flyer stock would be considered poor choice for a trust. And read the trust and see what it says. Is an estate tax return required? Only 1% of the people in the United States have to do an estate tax return because the level is so high right now. Above 12 million, as I said, above 24 million for a couple. And if you have to do it, you just have to appraise all the assets. A special needs trust. Now, this is just going to be an overview. What a special needs trust is supposed to do is to protect a disabled person, to protect their public entitlement program benefits. So it is an impenetrable trust from creditors if it's handled properly. So the beneficiary cannot create it themselves. A third party has to create it, like a parent for a disabled child or a relative. The distributions from this trust have to be discretionary and not required, because if there are required distributions, then a creditor can step into the shoes of the trustee and divert the required distributions. And the trustee should not give the ward money that's going to kick them out of an eligibility program for SSI or disability, Social Security, Medi-Cal. And then if you give them too much money, the ward, then they have to start over and they have to spend down all their money and then reapply later. There's complexities. You need to, the trustee needs to understand the entitlement programs. There's only a certain amount of money the trustee or the beneficiary can have. sometimes what will happen is they can't give the beneficiary a certain amount of assets. So what they'll do is they'll buy a condo for them and things of that nature. A lot of special needs trusts end up being unfunded. So they're created, say there's 5 children and one is special needs. You'll say these 4 children will get equal shares as individuals, and this beneficiary will get an equal share in their standalone special needs trust. Asset protection. There's huge asset protection abilities within trust law. First of all, I said that self-settled trusts are usually do not give you creditor protection, but and you go international, it's somewhat different. So you're splitting the ownership of an asset. There's the legal title in the name of a trustee, and then there's a beneficiary that has equitable title. The beneficiary still has enjoyment of the assets, and a creditor can only attach what a person owns or what they can control for their own benefit. And so structuring the asset protection trusts are irrevocable. And if they're revocable, they're considered a grantor trust, and the creditors can reach the assets. There's a spendthrift provision, which says that the beneficiary cannot assign or sell or give away their interest. Like a special needs trust, an asset protection trust must be discretionary. So, and usually they'll appoint a friendly trustee to preside over the assets. So a person wants to have a asset protection trust, and they have their uncle make a trust for them, put assets in there, and the beneficiary is not the trustee, nor can the beneficiary ever be the trustee, and the distributions are discretionary. Okay, so in United States, there are certain jurisdictions, what we call domestic asset protection trusts. So Nevada, Alaska, Delaware, you create your own first party created trust. And after a period of time, their law in that state says that creditors cannot claim those assets. And you have to have a trustee in that jurisdiction, and the trust must be discretionary. The settler is not the trustee. You have to have one local trustee in that state, and you have to have some assets in that jurisdiction. And because of the full faith and credit clause of the United States Constitution, other states have to recognize that. Now, foreign trusts are fund. They're governed under the laws of a foreign country, and people look for jurisdictions that are favorable to settlers. And those jurisdictions allow self-settled trusts to be favorable, and the fraudulent transfer laws, which you can undoes a transaction because you're defrauding creditors, are very lax. And some of them will not even recognize a foreign country's judgment. Some of the jurisdictions, for example, St. Vincent, Cook Islands, Nevis. So the way it works is you create a foreign trust in a foreign jurisdiction. You pay $35,000 to get this trust set up, and maybe $4,000 a year in local trustees fees. And then this trust creates an LLC in the British Virgin Islands. And the only person that can sign on the accounts in the LLC is the beneficiary. So it and if the creditor wants to bring a claim against assets, they have to go to that foreign jurisdiction and fight it in a foreign court. So you have jurisdictions. Oftentimes the assets are held in a different jurisdiction than where the trust is being managed. Assets can be moved all over the world. One case, the Anderson case, one time somebody became subject to contempt, but that was a real bad fact pattern. And they are used around the Panama Papers is an example a few years back, where foreign trusts, a lot of people had them all over. Never appoint a foreign trustee on your American trust. It causes the trust to be treated as a foreign trust for IRS tax purposes. So only US trustees. So in conclusion, trusts are important for multi-generation asset planning. Trusts allow for the creativity of the settlor on how the trust works. Trusts work very well for some people, and they're not even necessary for estates of moderate means. And trusts are not perfect. There's advantages and disadvantages. And what I like about it is that there are very few legal limitations on what a person can include in drafting a revocable trust. Okay, so we're about an hour and a half into this, and I would like to hear some questions if there are any.
Yes, there are plenty of questions here.
Okay, great.
Let me go through them. Is the I Love You Trust the for probate avoidance form?
Yes is the answer. It is a trust. All the assets in the trust will avoid probate.
Okay. Many clients don't have stock certificates or LLC membership certificates for small business held in these entities. Will an assignment suffice, or does the certificate part need to be done?
There's what you can do and what you hope works. I suggest doing both, the assignment and issuing the shares, because then there's no question. I know another practitioner who thinks issuing the shares is ridiculous. I don't. I have seen many companies, you buy them, these entities online, different things, and there's no proof that you own anything. And a share certificate is like a deed on a house. So I'm not saying that a business assignment of personal property will not work, but why do it when you have greater assurance by issuing shares?
Okay. Isn't a bank medallion only available while the account holder is living? What happens when you need to transfer funds to an heir without a medallion using a declaration under, where did the question go? Uh-oh. Using a declaration under PC 13100.
Well, I don't know that code section off the top of my head, but I will give you an example. We were working with a decedent's estate. It was a trust, and they had a valuable limited partnership interest. And the person was gone. And we're working with a successor trustee, and she had to get a medallion signature from a bank that knew her personally in order for ComputerShare to issue the replacement certificates, and to boot, they charged $1,900 to issue those shares.
Oh my. Okay. Isn't it appropriate to transfer property by a RM into a trust so that the heirs can keep the equity out of probate that is not subject to the RM payoff?
I don't know what an RM is.
Okay. Neither do I. If you want to elaborate on that question, please go ahead and elaborate on that. Another one, when putting together a second amendment, can you revoke the first amendment, taking care to make sure that the new amendment incorporates the language from the first amendment if still valid?
Why is my question. If you're going to do amendment, you know, what they're talking about there is either or, either or. You can supersede a prior amendment and say it's void, write void on it. I wouldn't throw it away. I just don't like the way it's structured. I mean, for me, people come in and say, is my trust still valid? And they created the trust in 2002. And I say, it's going to take me more time to look up every clause to see if the law has changed on every clause than it's going to take me just to issue a new trust with the current law. And then we amend and restate. I'm not a fan of too many amendments, or they're difficult to deal with.
Okay. Alrighty, another question, and this is actually a question from me. I have a client who wants a restatement of a trust created in 1993. The wife has dementia, but he has POA. Can he sign as attorney in fact on documents requiring her signature, excluding her will, of course, that will stay in place?
Okay, I'll translate the question to a little different slant. He's the successor trustee. He can sign on documents as successor trustee. The durable power of attorney is for assets outside the trust. And I'm not sure that I answered the question right. Did I miss the point?
He wants to update the trust, but she's not able to because she has dementia.
Most of the time, the trusts that I see require both spouses to be competent at the time of an amendment. It's normally written in that way. So you're bound by what the original trust said. Did it allow it? Did it say it's amendable while both spouses are alive or competent? It seems there that you need to dig into the drafting of the document.
Okay. Okay. And the kids are all in agreement for it to be, restated. So there wouldn't be any fighting or anything like that.
Yeah, there's a couple code sections. One, to amend a trust, even irrevocable, if the settlor and all the beneficiaries agree, you can do it. Irrevocable to change it. If one of the settlors is passed and you want to change an irrevocable trust, the code says that you're supposed to bring that change to court and get it approved by the court.
I see. Okay. Awesome. Okay. For a trust protector, can you expound on the ability to amend the trust because of changes in the law?
You write in a clause that says laws are constantly changing, and we give the trust protector the right to change the trust to comply with future laws. I did one recently where it was halfway between California and New York, and I gave the trust protector to choose the law that they wanted to use on a line-by-line basis. They could pick California or New York, and it just allowed them to do that. I don't know if that answers the question completely.
Okay. Is the non-U.S. citizen exclusion based on each gift or a total of all assets left to non-spouse?
The total of all assets left to non-spouse, non-citizen spouse at fair market value.
Okay. Is it my understanding that the permanent residence alien was treated the same as a citizen and did not need the QDOT? Is that correct?
No, absolutely wrong. Citizen is citizen is citizen.
Okay. Please discuss again regarding non-citizen spouse. Does the lower exclusion amount apply to persons with residency or a green card?
Yes. They're not a citizen with a resident alien or green card. It does apply, and there's the estate tax to worry about.
Okay. Does the 1-year time limit for a claim against a trust include taxes?
I did not say it that way. What I said was, when a person dies, the creditor has 1 year to file a claim against a decedent for creditor claims, and the government writes the laws, and I don't think you're going to stop the government from asserting claims.
Okay.
So the answer would be no, in my view.
Okay. If there is a conservatorship of the person, will the successor trustee / financial agent have to give an accounting to the court of how the assets are being used?
Okay, so we have a DPOA financial management and a trust, and under the DPOA, they're required to keep good records, but they're not required to issue reports normally. The requirement is not there. Beneficiaries can force the requirement by requesting it.
Okay. The statute of limitation of 3 years for objection to trustee duties, is that from date of death of settlor or from date of discovery of such issue?
It's date of discovery of their real or imagined claim.
I like that, real or imagined. Can beneficiaries waive the 120-day period?
I'm not sure which 120-day we're talking about. In beneficiaries can accept an accounting with no notice at all, and they just take it and sign off on it. In the objection for an accounting, it was a minimum of 180 days, and that limits the beneficiary to complete their claim within that 180 days if they're going to object. So it's not really something that the beneficiary has control over.
Okay. All righty. Do you think an LDA should prepare irrevocable trust, or is this a project that requires an attorney?
I don't know, and I am uncertain. And so LDAs can do estate planning. There's no problem in that. And in reality, most revocable trusts become irrevocable at some point in time in the future. And when somebody starts talking about creating irrevocable trust from the beginning, the first question comes up, why? What's the purpose? And it's ironic, but irrevocable trusts are not irrevocable. It sounds goofy, but it's true. You can have, what it means when a trust is irrevocable is the settlor cannot revoke it. You can name a trust protector and they can revoke the trust anytime. So I think that perhaps LDAs can prepare it. I just don't understand enough about the question.
Okay. Are there negative implications for trusts created by non-married couples?
No, there's a lot of good that comes from non-married couples creating an estate plan together. We had one example where a long-term partnership, unmarried, the gentleman owned the house and they, years and years together. He died and the wife, the woman couldn't even get in the house to get her clothes out.
Wow.
Which is a bad scene. Had there been a trust, It said, well, it says that she has the right to access, or she's gonna, you know, it would be well defined. So
Mhm.
I think it's very good that unmarried couples do an estate plan. It just clarifies things.
Absolutely. And in RE of funding, in regarding funding an LLC, do we file an updated statement of information with the Secretary of State showing the name of the owner as trustee of the trust? Example, Joe as trustee of the Sword Trust.
Okay, what they're talking about there is called an LLC 12 form. It's a statement of information that has to be filed every couple of years. And the form asks who the manager is and what the agent for service of process is. That form does not ask who the owner is. So it does not become a public record, and it's not required to be disclosed on the LLC statement of information.
Okay. Someone type PC 13100 is the small affidavit under probate code 13100. If we prepare a restated trust, should we shred the old trust and the amendments?
Okay, there's differing views on that situation. I am one that doesn't like shredding and destroying. You can write across it saying revoked or restated on this date, but I suggest keeping the old documents because we never know what happens. And sometimes it comes in handy.
Mm-hmm.
It says revoked on it. And in your new document, it says revoked. But, and then comes up the person, they lack capacity. They didn't know what they were signing. So then you go back.
Mm-hmm. Okay, is it a good idea for a mother and adult child to be trusters of the same trust if they own property together rather than as JTRWOS to avoid probate?
Okay. Joint tenancy is a sore spot with me. I don't like it. It's not good. You cannot do estate planning. There's a significant downside to joint property for income tax purposes. So there's, let's say, two people own the property. It's gone up a lot in value, and one of the people dies. Only half of the property gets a step up in basis. And not only that, if there's money needed in the estate administration, having a survivor, it's by operation of law. Yes, it avoids probate. And my answer to that is, so what, big deal? It seems to me when you put it in a trust, you can define exactly what you want.
So if you have, let's say that you have an unmarried couple who have a trust, and let's just say only one of the individuals gets a trust, but the property is in both of their names, but the property is in joint tenants in common.
Okay, so joint tenancy is fine. You can have two owners and a trust can be and one of the joint owners. What is usually preferred is tenants in common, TIC. And the purpose of tenants in common is each owner has the right to distribute their property on their death any way they want. And to me, that's the preferred way, is get out of joint tenancy, put it in tenants in common, and you can have two trusts owning half and half. You can have one trust and one person. It's okay. But I suggest tenants in common is a better approach.
Okay. Okay. Can government student loans be creditors for a trust?
I doubt it because it's personal liability. So an individual signed up for it. There's no asset being secured like real property. And the individual, no, it's not a debt of the trust.
For the non-US citizen spouse exclusion amount, is community property also included under this exclusion?
The answer is yes, but the way it's excluded needs to be defined. So community property on death splits in half. There's two halves of the ball. And what's inherited is the half of the deceased spouse. That's what's valued. The other half is already owned by the non-citizen. So it's only the part that they inherit that is subject to the inheritance tax above 164,000.
Okay. What software do you recommend LDA use for estate planning?
I only recommend for myself, I like ForTrust. There's Adapt. Nolo is pretty good. California Wills and Trusts is good. There's several others. I am most familiar with California Wills and Trusts and ForTrust desktop. I haven't worked with the Adapt, which is part of ForTrust online. There are many, and I would suggest playing around with them to see what you like. Take a demo.
Okay. And here's a comment. I have had a financial institution ask for the underlying trust after an executed restated trust to verify the name of the trust. So good idea to keep the underlying trust. And then here's another comment. Insurance companies don't want to insure automobiles in a trust because they don't know who they are insuring, the owner of the automobile or a successor trustee.
And I agree with that. And my comment was, we don't normally put cars in trust.
All right, so that is it. No more questions. We don't have any more questions here. Another awesome presentation. Tons of information.
Yeah, I had fun putting it together. I was racking my brain trying to get everything that I thought would be useful for people and not be limited by the normal type of transactions.
Absolutely. I'm going to have to go back. This trust that I'm working on, it's from 1993. It's all over the place. And now I'm going to make sure I go back and see whether or not. So do you think it would be beneficial for me to get something signed by the, the heirs, the children? It was 3 children, one passed away, and they want to leave her share to her husband.
I'm a little lost, but if the trust is still revocable, you just update it. But I'm kind of confused in the fact pattern. Who's on first?
Well, the mother has dementia, and so the father wants to update the trust.
And is she subject to a conservatorship?
No, she's not under a conservatorship.
And he has a durable power of attorney for asset management.
Yes, he does.
And he's a successor trustee.
Yes, he is.
Okay, you have to read the trust to see if they permit it.
Okay, yeah, that's what I was saying. Yeah, that's how you answered it earlier. I'm gonna have to go back in and redig again. I just want to stay on that fine line of not giving any legal advice.
It's tough in that situation because you have a lot of overlapping situations, and you might want to get an attorney's opinion that, okay, you can amend it, or no, you can't. I am concerned when you have an incapacitated person that the courts tend to look at those people as subject to predators. So anything you try to do ends up with this assumption that it's predatorial.
I see. I might be sending it to you, Rex.
Okay, but it sounds like that it might need court approval. So what they have in court for incapacitated persons, they have a thing called a motion for substituted judgment. And what that is, you use the court to give an opinion what the person would have really wanted.
Okay.
And that's a way to overcome that. So if a judge signs off that says, yes, under the substituted judgment law, we want this trust amended because it's clear that's what the settler wanted, why she was competent, and the beneficiaries are all in agreement.
Okay. Awesome. We have somebody that's and thank you so much for that. I really appreciate it. Here is another question. They're rephrasing a question. Can a beneficiary waive the 120-day period to contest the trust administration after receiving the notice of trust administration?
Can the beneficiary waive it?
Yes.
What it is the beneficiary has the right to bring a claim, but it's statutory. I'm tending to think that the answer is no, because we're dealing with a statute. So you say, I don't want to apply the law. Hey, I don't like it. Okay. I don't think so.
Okay. All righty. And let's see. Even if the cars are expensive, do I need to put them in the trust? Well, she didn't put a price there. Let's say, I don't know, $95,000 car.
Okay. So what we're talking about, we have real property and personal property. This is not real property. We have a general assignment of all personal property, which includes vehicles at any value. So you have already assigned it, and it's been notarized that the trust owns that asset. You're done. It doesn't have to show a DMV.
It doesn't, the DMV title does not have to be changed in the trust name.
No, you assigned personal property.
Okay. Okay. And that is it. No more questions. Again,
Okay.
thank you so much. It has been. All right. You take care, everyone. Thank you so much for attending. We'll see you next month.
Okay. Very good.
Okay. Bye-bye, everyone.
Bye.